Thank you.
Chair thanks the gentleman and recognizes the gentleman from South Carolina, Mr. Gowdy, for 5 minutes.
Thank you, Mr. Chairman. Director, I want to thank you for your service to our country, both in the military as a prosecutor and as a law enforcement officer. I want to touch on 3 different areas. I want to start with the Rosen affidavit because it states in pertinent part there is probable cause to believe the reporter has committed a violation of the Espionage Act. And this is the phrase I want to focus on. At the very least, either as an aider and abettor and or a co-conspirator. If the standard is probable cause, why in the world would the affiant add the phrase at the very least if they weren't contemplating a prosecution?
I don't know why the person would have added that statement.
Well, you were a very distinguished federal prosecutor. I was not at all distinguished, but I was a prosecutor. I don't remember ever adding surplusage, extra wording to an application for a search warrant. So I'm vexed by why the affiant would say at the very least.
I just don't know.
Also in the application for search warrant, they requested a non-disclosure order citing the 5 different reasons. Now, it was my experience, and I assume yours, that the affiant is under oath when they appear before a judge.
Yes.
Do you know which of the 5 categories that would need to be shown for a non-disclosure order was testified to in this case? Which of the 5 reasons statutorily that you can seek a non-disclosure order were at play?
I'm not that familiar with the facts to be able to answer that.
But you would agree with me that when you're before a judge and you are swearing out your affidavit, if you're asked for a non-disclosure order, you have to have some evidence that one of those 5 factors is in play.
Well, I'm not all that familiar with the statute. I will say that when you file an affidavit, everything in there ought to be accurate, and you ought to be prepared to swear to every item in that.
All right. Do you ever recall discussing the Rosen investigation with the Attorney General?
No.
Do you know, well, let me ask you this. If the affiant said at the very least there is probable cause to believe a crime has been committed, was there discussion of indicting Rosen?
Not that I had.
If you had more than probable cause, why would there not be discussion of indicting?
Well, there may have been discussion, as you well know, with the Assistant United States Attorney and the agent in terms of what went in the affidavit. You've done any number of hundreds probably of affidavits yourself, and the discussion between the lawyer and the agent is for the lawyer to get what the agent knows in the course of the investigation and get it written up so that you get the approvals that you need. I'm sure that happened here. Did not come up, does not come up to my level to have that kind of discussion.
All right, so it is fair to say that you were not part of any conversations with respect to whether or not something along the lines of an indictment should be considered for the reporter, but you do not know whether or not the conversations took place. But you yourself were not part of them.
I was not and had none.
Okay. Does the Bureau have a policy with respect to shopping judges or not shopping judges? If you go to a magistrate or you go to an Article III judge and you're denied, is there a policy within the Bureau on judge shopping?
No. Not that I'm aware of.
All right, let me switch gears. There was an allegation this week of American diplomats being involved in the alleged solicitation of prostitution overseas. Would the Bureau have jurisdiction to investigate that?
I have to look at that. Initially I would say, well, I'd have to look at it. I'd say no, but there may be, off the top of my head, maybe I'm missing something. I have to get back to you on that.
If there were an allegation that the State Department attempted to interfere with or influence the investigation, is that something the Bureau would have jurisdiction over?
In first instance, I'm not certain. We may. Going back to the question about the activities overseas, if it implicated the disclosure of U.S. secrets, for instance, and we would have perhaps some predication for being involved in the overarching investigation. As to the second question, I just can't say.
I've been out of the business for a while, but I think it may be a crime to travel for the purpose of soliciting underage sex. I could be wrong about that.
Underage, yes.
All right.
I do believe that that would be covered, but I have to check on that. I have not done.
All right.
I have not done this work for some time.
Yes, sir. All right. Finally, with respect to Benghazi, and this is not a trick question, I think the answer is obvious. The quicker you get to a crime scene, the better you're going to be able to investigate it and process it, right?
Absolutely.
All right. And the Bureau did not get to the crime scene in Benghazi for how long?
I think 2 weeks.
And why did the Bureau not get to the crime scene in Benghazi for 2 weeks?
There were a number of factors. The first one relates to the state of security in Benghazi. There was no security.
All right. I want to just stop you there because I want to ask one more question and my time is out. I am asked all the time back home in South Carolina, if Benghazi was not safe enough for the premier law enforcement agency in the world to go, how was it safe enough for us to send diplomats?
It's another question that is not in my bailiwick. I understand the question's being asked. I presume it's a rhetorical question.
It's rhetorical unless you know the answer. I can't answer it. I don't know.
All I'm saying is rhetorical or not, I can't answer it.
It is a good question, but the time of the gentleman has expired, and
Thank you.
we will look for opportunities to ask it again. And the chair now recognizes the gentleman from Georgia, Mr. Collins, for 5 minutes.
Mr. Director, I appreciate you being here, and I appreciate by the time we get to this, there is sometimes rhetorical questions that seem to pop their heads up. And I think in this question, though, my friend from South Carolina brings a very good point. There are things that people out in the world look at and they see, and they're honest, hardworking folks, and they look at these things and they say, this doesn't make sense. And I think it just attributes to the disconnect that many times happens with the folks who get up and go to work every morning and they look on their TV and they see what's happening up here and they say it just doesn't pass the smell test. And I think that's some of the things that we're concerned about. But I want to go in a different direction. We've covered the gamut. Our country wants to be safe. The people of the 9th District, they want to know that their government is watching out for them. They want to know that there is sharing, legal sharing, and not overreach, but legal work that is hard work between police and law enforcement agencies and the Justice Department. My father was a state trooper for 31 years in Georgia. I get it. But there needs to be a balance in there. So there's a program called the Joint Regional Intelligence Group. And I want to switch gears here. The Director of National Intelligence issued a directive establishing the Joint Regional Intelligence Group pilot program. The purpose of this program will be to coordinate information sharing between foreign and domestic intelligence communities. We have been hearing from state and local law enforcement that the FBI has largely taken control of standing up the pilot program and that they have been excluded. Is that the case, or is that your understanding of what's going on right now?
And who would be excluded?
The local, state and locals feel like they're being excluded.
This issue I think we've addressed in terms of the regional intelligence centers. I know there was some concern at some point that this is some new vehicle. We have, I think, explained sufficiently to state and local law enforcement that this is not anything new. It's a greater integration of the intelligence capacity around the country.
So you're saying this is an existing program, and what the Director of National Intelligence is saying is not new?
Well, I'm not certain exactly which program the Director of National Intelligence is talking about. I thought you said regional.
The Joint Regional Intelligence Group.
Joint Regional Intelligence, yes. And it certainly includes state and local law enforcement, and there are various parts of that particular undertaking, and you have to differentiate between the various parts of that undertaking. For instance, part of it is the role of our special agents in charge as being in the various divisions, as being in charge, and being the person who is in charge for intelligence collection, or coordination, I should say, under the ODNI.
Okay. Now, so, and again, the understanding here, tell me a little bit more about this program. Maybe we're talking about the same program, maybe we're not. And I think that's because this seemed to be more of a pilot program, which would mean that it was either integrating stuff that was already there or starting something from new that may have been and if that is, where is this being located out of?
I guess I am confused in terms of specifically what programs you're talking about under the ODNI. I'd be happy to get back to you specifically on this as I can read it and assimilate it.
All right. In light of that, and I know and we'll move on, and I appreciate you getting back to me about that and those questions. A lot has been said about the Electronic Communications Privacy Act. We've sort of danced around a little bit of that. As you're sort of in your last little bit here, I want to sort of open this up and say, is it out of date? Is it something that, is there better, would it be helpful for law enforcement to have a clear standard of collection? And if so, what do you believe that would be?
Well, yes, I do think it is outdated. It does need review. As I indicated before, I would caution against raising standards for obtaining basic non-Fourth Amendment information because you eliminate much of the data that provides predication for further investigation. And so as one looks at it, I would look at it to be updated, but also I have some concern about raising standards which would impact on our ability to conduct cases, and whether it be terrorism or otherwise.
Well, as I have a law professor who's basically lamented many times on the demise that there was even a Fourth Amendment even existing today in the light of a lot of things and cases that have been going on. Is there a way, though, that we balance this in a new age of environment in which it seems to be metadata, we call it these things where it's collection, but we're collecting on such large scales in this electronic life? Do you think we've got a pretty hard line to focus here in which we're protecting civil liberties of our individual, yet giving access where need be, where I think people would understand there'd be a reason to investigate?
I do think that given the new technology, the ability to communicate in any number of ways, that the statute needs to be upgraded. The concern comes, you can identify terrorists by looking at substantial accumulations of non-Fourth Amendment protected data. And in the case of a terrorist who wants to undertake an attack to kill Americans, it may well be worth that balance. On the other hand, what you want to protect against is abuse of that collection of data.
Well, and that hits, and the concern I've had, and our time is done, but the quick question, depending on many-year-old court decisions on what is, quote, metadata and what is protected for, I'm concerned that we're in a situation now to where some of the older rules of things that didn't understand this kind of technology may be balanced in a way that we're going to have to look at it differently, instead of saying, well, it's always been okay under these circumstances and now try to apply it. Now, I think we may be trying apples and oranges, and I think people are concerned about that. Thank you, though, for your service. Thank you for being here to answer the questions, and I yield back.
Thank you.
Mr. Chaffetz for 5 minutes.
Thank you, Mr. Chairman, and to the Director, thank you. You've made yourself regularly available to this committee, and as a member, it's very helpful, and we appreciate it and appreciate your service. I want to talk a little bit about geolocation, metadata, and specifically the Jones case, which is a Supreme Court ruling where they ruled 9-0 that a GPS device placed on a vehicle for an extended period of time was an unreasonable search. Geolocation is broadly defined as using a GPS device or triangulation so that you can tell the specific whereabouts of where a particular phone is. Could you help me define what metadata is? Because what we've seen in the news is that the metadata category is the simple telephone number, where they're calling, and how long they're calling. Can you help me define what else is in the so-called metadata category?
Well, in the case of emails, it would probably be header information. I think people would consider
what about specific
addressing information, but not the subject line, for instance. That would not be metadata. In terms of the telephone, it would be that which you articulated principally.
Would it include geolocation information?
That's a question I'd have to get back to you on. I had not thought about that.
We submitted in advance our questions that we were going to ask here today, in part, so I could have a candid dialogue with you. We were very good at providing the questions that I was going to ask. With all due respect, sir, you're the director of the FBI. You've been there for 12 years. You had to have think post-Jones, what are the implications of the Jones case? What is geolocation, and how does it apply?
Absolutely. I mean, we have been, after the Jones case, we have taken, and the Jones case can be applied to a number of ways that we utilize geolocation. In each of these different ways, we have taken the most conservative approach because you don't know what is going to be the progeny of Jones. On the particular question of whether or not geolocation is metadata off the top, well, I shouldn't do it off the top of my head. I have to make certain that I look at that one.
Is there a database of geolocation information that is warehoused by our federal government?
Not that I'm aware of.
Post-Jones, there has been guidance given by the Department of Justice to the FBI. I would love to see that information and share that. I've seen 2 unclassified documents that were through a Freedom of Information Act. Is that something that you can share with this committee?
I'd have to look at that. But if it's unclassified, internal, then I'd have to look at that.
All right. I guess what I have a problem is this phone right here, the federal government has no problem following this phone, who I call. If I call my 12-year-old daughter, the telephone number I called her on, how long I had. But the geolocation is something that I have a bill that I've sponsored that would record, that really basically categorizes geolocation as content as opposed to metadata. So if you're going to follow what this telephone number is, where it is that or is that not content?
Yeah, I think that's I'll tell you, I think it's a very difficult question, and I'd want to think about it. It can be metadata, it can be content, and it may depend on the circumstances.
But is there a database that anybody knows of that
I do not know of a database that specifically is addressed to geolocation, apart from anything else, other investigative activity that is solely a geolocation database.
Post-Jones, does the FBI believe that there should be a lower or different standard for law enforcement to access geolocation information from smartphones or other mobile devices than the standard for attaching tracking devices to cars under Jones?
I have to get back to you on that. I apologize. I can see you gave the questions, and I did not get briefed on. It's my own fault. We're getting briefed on the questions, so I'm better able to answer them.
I appreciate it. And, Mr. Chairman, it's terribly disappointing to come to this point, talk about something that is in the headlines of every newscast. I gave the questions in advance.
And they noted that I would be asked on that, I might add. So it's my fault.
Your staff did some good work, I guess, but it's terribly frustrating, sir. You're the head of the FBI. You're the director of the FBI. This is not... this is an important discussion and dialogue, and I know I won't get an answer, and that's the frustration.
I will be happy to meet with you after I've had a chance to review the questions you have and the answers that you need.
What would be a reasonable time frame for me to start to call foul and say, hey, where's this information? Okay, I appreciate it. Thank you, sir. Yield back.
Gentlewoman from Washington, Ms. Delbaney, for 5 minutes.
Thank you, Mr. Chair, and thank you, Mr. Director, for your service and for being with us here today. I happen to agree with those who believe that greater transparency and better data about the requests that government entities are making to Internet companies and providers will help inform the discussion that we're having about how to balance legitimate national security needs with privacy rights. I understand it was referred to a little bit earlier that Google sent a letter to you and Attorney General Holder earlier this week. Requesting that it be permitted to provide reports of the number of FISA national security requests it receives as well as their scope. And I wondered if you could share with us what your response is to that request.
I think that's being looked at by Justice at this point.
Okay. Then earlier this year, Google did work with the Department of Justice and the FBI to disclose in broad strokes the number of national security letters that Google receives. And did Google's disclosures of these numbers harm national security in any way?
Well, let me just hypothesize without answering particularly. If you had such figures out there, would not somebody who wanted to have secure communications maybe make some decisions as a result of that information as to what, what communications capability they use? So it's basically there are issues that need to be discussed in the course of deciding what needs to be declassified. I think most of us in the government would love to be able to disclose more because it would be more understandable to persons, but you have the conflicting values of trying to protect the country and trying to protect that information that enables us to continuously identify and to intercept the communications of terrorists in an effort to thwart attacks. That's the conflict.
Thank you. The committee is currently also considering reform of the Electronic Communications Privacy Act. And as you may know, the Senate Judiciary Committee recently reported reform legislation out of committee. Members on both sides of the aisle seem to agree that we failed to modernize our law to align with reasonable expectations of privacy, especially in the digital age. For routine criminal investigations, I believe law enforcement should use the same standard to search your inbox that they do to search files and letters in your home. But our current outdated law allows police to provide only a subpoena issued without a judge's approval to force service providers to turn over emails that have been opened or are more than 6 months old. The committee is currently considering legislation that would require government entities to obtain a warrant before having access to stored content. And I'm pleased that the Department of Justice and Attorney General Holder recently acknowledged that reform to the Electronic Communications Privacy Act has failed to keep up with the development of technology. And I wanted to know if you agree that it's time to reform these laws to include a warrant standard for stored content.
Well, I would agree that it's time to relook at these laws given the communications in terms of what the impact on it would have on particular requirements in particular situations. I would wait to see what kind of legislation is proposed.
Do you have a proposal of what kind right now? If I have a physical letter, a piece of paper in my home, you need a warrant. If I have an online piece of communication, it doesn't necessarily have the same standard.
We'd be pleased to get back to you either by regular letter or by email.
And in terms of broader reform, in terms of keeping up, do you have recommendations on other reforms you think that we need to look at? Because the way that folks have communicate now is very different than the past. You talked about chat and other forms. Clearly, our laws have not kept up with the changes in technology. And do you have an opinion or ideas of how you would like to see legislation formed there?
Yeah, we'll get back to you on that with whatever ideas we have. I do think there needs to be reform. There is always an impetus to increase the standards to get particular documents, but it should be done, in my mind, dependent on the attributes of privacy that are necessary for a particular means of communication or a particular piece of data relating to communications. If you raise the standard too high, we then do not get the basic information that can identify terrorists to the point where then we can take the additional investigative steps. Identify the subscriber. Once we've identified the subscriber, identify others in that network. If we, as a result of that predicated level investigation, find that they are involved in terrorism, then getting a wiretap. We tend to confuse that which is covered by the Fourth Amendment and that which is not covered by the Fourth Amendment. And so as one drafts the legislation, my belief is that ought to be kept in mind.
Thank you, and thank you, Mr. Chair. I yield back.
Chair thanks the gentlewoman and recognizes the gentleman from Utah.